Schools tend to ask me a lot of questions about the Terrorism Protection of Premises Act. These are the 4 questions that come up most often that I'd love to clarify in these videos. Yeah, I think what we're finding when we're speaking to schools is a lot of school leaders think that their sites are already compliant, given a lot of the process and policy they already have in place. Unfortunately, that tends not to be the case. The classic example we always talk about is fire evacuation plans, and how a fire evacuation plan will try and get you out of every single exit. Clearly, in the context of a terrorism incident, that can be problematic, as you may be pushing staff and pupils into the pathway of an oncoming attacker. The other thing we find that schools struggle with is the idea of showing what's reasonably practicable for their site, given the level of resource that they have and the number of people on site. ProvaRisk obviously helps people to understand what is reasonably practicable and formulate plans and procedures that are specific to a terrorism incident. The vast majority of schools will find themselves in scope. The threshold they've got to reach is 200 people on site from time to time, and that can be pupils and staff and any visitors. So you're also talking all your support staff, groundskeepers, handymen, the kitchen staff, any and all will be part of that 200 threshold, let alone when you have specific events where you might have lots of visitors on site, like parents. All of that, if you can foresee it happening and it's going to breach that 200 person threshold, that will put you in scope. One of the most common times of years is obviously going to be Christmas. Nativity plays will almost certainly see a lot of visitors on a site. If you've got a school of 100 children or 100 pupils, almost certainly that will tend to reach the 200 person threshold. So there's definitely some nuance as to who is legally responsible for schools. The definition under the legislation is the responsible person, which can be an individual or entity, but it is that entity or individual that is legally responsible for that site in its primary use. For schools that you find are state-run, it is generally the Board of Governors of that site that will be a legally responsible person. They will almost certainly delegate to the head teacher, but the head teacher is not the legally responsible person. For a multi-academy trust, it is the trust itself, not the individual school. And for pupil referral units, it's the local authority that will be responsible for ensuring all the public protection procedures are in place. So a lot of larger schools are concerned that they may fall into the enhanced tier of the legislation. That's not the case, thankfully. Under the legislation, there is a specific buy for early years, primary, secondary and further education sites, whereby even if they can regularly expect 800 people or more on the site, they don't fall into the enhanced tier, they only stay in the standard tier of the legislation. Whereas tertiary education institutions and private education institutions, they abide by the normal legislative requirements. If they can expect 800 people or more on site from time to time, then they will be in the enhanced tier of the legislation. If you've got any more questions on Martyn's Law or the Terrorism Protection of Premises Act, head over to provarisk.co.uk. You'll find the Martyn's Law page, and in there is a wealth of information about the legislation.